Fraud is a constant threat to your notary commission. You need a shield. The book by Derek Spruill, Notary Fraud Shield, could provide you with some advice. Learn real-world tactics, notice red flags, and develop refusal strategies to protect your notary commission. Buy your copy of Notary Fraud Shield by Derek Spruill from any online bookstore, Amazon.com, Barnes & Noble Bookstore, booksofmillion.com, bookshop.org, Mobile Notary by DerekSpruill.com, or download from Kindle to obtain your essential notary book to help with all your notarization starting today.
Welcome to Notary Knowledge.
And we have a really intense one today.
We do. So look, today's mission, we're doing something a little different, a little more high stakes. It's a game show format that we are calling Decoding the Trust, Advanced Estate Plan Trivia.
I love that title.
Right. It sounds official. So, in previous shows, we've talked about your basic acknowledgments, car title, simple forms.
Everyday stuff, yeah.
Yeah, exactly. But today, we are tackling the complex, highly private, high liability world of estate planning.
Oh, yeah. It is a completely different landscape. The stakes are just, well, they're astronomical.
Completely. Which is why, before we even jump into this trivia, I've got to say, if you want to level up your skills and protect yourself, you really need to buy the Notary Knowledge books by Derek Spruill.
Absolutely.
You can just go visit the Notary Knowledge website. Seriously, it is your survival guide for the kind of stuff we're about to cover.
It really is. You cannot rely on guesswork with estate documents.
Right. No.
So, here's how the run of show is going to work today.
Yeah, break it down for us.
We're going to run through 10 multiple choice questions, or MCQs. And for each one, we'll give you a real-world hook, the question, and the options.
And we'll give you, a couple seconds to actually think about your answer.
Right. And then comes a reveal. But we're not just giving the answer. We're going to analyze it based strictly on actual state statutes and E&O errors and emissions court cases.
Yeah, the real stuff that gets people sued.
Exactly.
Okay, let's jump right into segment one. We're calling this the Trustee Trap and Complex Executions.
Okay, the Trustee Trap. I mean, trusts are inherently private documents,
Right.
They're designed to keep things out of probate court, which means they were a total minefield for UPL, the unauthorized practice of law.
Yeah, people just stepping way out of their lane. So here's our first scenario, MCQ1. Let's talk about Tyler down in Tennessee.
Okay, Tyler in Tennessee.
So Tyler's a notary. He's at a bank, and a bank manager comes up to him, very rushed, and slaps a 60-page trust document on his desk.
Oh, boy.
Right. And the manager asks Tyler to verify that the signer sitting there has the legal authority to act as trustee under, Section X of this massive binder.
That happens all the time.
So here is the question. What is Tyler's legally compliant response? Option A, he reads the trust and verifies the clause. Option B, he refuses and requests a certificate of trust. Or option C, he just attaches a loose certificate and stamps it anyway to make the manager happy.
So take a couple of seconds to lock in your answer.
Yeah, TikTok. I mean, you got a very angry bank manager staring at you. It's tough.
It's pressure for sure.
All right, time's up. What is the reveal here?
The reveal is B. You have to refuse and request a certificate of trust.
Okay, so you can't just flip to Section X and read it.
No, absolutely not. Interpreting a trust is a textbook example of UPL. Yeah, under the Uniform Trust Code, specifically Section 1013, which applies to Tennessee, a certificate of trust is used to summarize those powers.
Ah.
And in Tennessee, like about a dozen other states, major institutions actually treat the notarization of this specific certificate as mandatory. You cannot just read the big document.
So I like to think of it like this. It's almost like the full trust is a company's highly confidential, recipe book, right?
Yes.
And the certificate of trust is just a VIP pass.
I like that.
Yeah, the notary just verifies the VIP pass. They don't read the recipe.
Exactly. You verify the identity on the certificate. You do not analyze the recipe.
Okay, awesome. Let's move to MCQ2. This is about split signings in counterparts.
Oh, this gets messy.
Yeah, so imagine a trust requires two co-trustees to sign a document. One lives in Seattle, Washington.
Okay.
The other lives in San Francisco, California.
Happens all the time with families spread out.
Right. Wealth is everywhere. So how should the California notary handle the pre-printed certificate that explicitly lists both co-trustees if only the California trustee is physically present in front of them?
Right, because the other guy's in Seattle.
Exactly. So here are your options. A, stamp it as is. B, strike a neat line through the Washington trustee's name and initial it. Or C, refuse the notarization entirely.
Okay, think about it for a second.
Yeah, you've got this paper, 2 names are on it, only 1 person is in the room. What do you do?
All right, so the answer here is B.
Strike a line through it.
Yes, you strike the absent trustee's name, or ideally, you use a separate loose California compliance certificate.
Because if you just stamp it, you're basically lying, right?
You're committing fraud. You are certifying that someone in Seattle is standing in front of you in San Francisco.
Right, right.
So this is what we call the counterpart solution. Each trustee signs their own individual page in their respective states.
Oh, so they don't even have to sign the same physical piece of paper?
Exactly.
Yeah.
But in California specifically, using that loose certificate is much safer because of the 2015 Consumer Notice Box requirement.
Right, that huge box at the top.
Yeah, the one that explicitly says you are only verifying the identity, not the truthfulness of the document itself.
Got it. Okay, let's keep moving. MCQ 3. We are heading to Florida.
Okay, the Sunshine State.
Yes. So we are executing the, quote, testamentary aspects of a revocable trust in Florida.
Very strict down there.
So the question is, how many witnesses are strictly required by Florida Statute 736.0403 to prevent the trust assets from falling into probate?
Good question.
Option A, none, just the notary. Option B, 1 witness. Or option C, 2 witnesses.
Okay, give everyone a second.
Yeah, think about Florida. Think about all those retirees down there.
It's a big deal. All right, the reveal is C. 2 witnesses.
2 of them.
Yes, and these witnesses must sign in the presence of the settlor, the person making the trust, and, critically, in the presence of each other.
Wow, so everyone has to be in the room together.
Exactly. And here is a huge trap for notaries.
Uh-oh.
If you are a notary executing a self-proving affidavit for a companion, or at that exact same table, you absolutely cannot serve as one of those 2 witnesses.
Wait, really? Why not?
Because you can't notarize your own signature.
Oh.
Right. If you're a witness, you sign.
Hmm.
But then the self-proving affidavit requires you to notarize the witnesses. So you'd be swearing yourself in.
You'd be stamping your own name. Yeah, that's just a massive conflict of interest.
Exactly. Don't do it.
Wow, okay. That's a perfect time to take a quick breather. Before we get into segment 2, I want to give a huge shout out to an app that actually helps you track all these crazy witness requirements.
Oh, absolutely necessary.
Yeah, I'm talking about the One Ledger Notary e-Journal. You can grab it right now in the Apple App Store.
It's a lifesaver.
It really is. And it was crafted by the incredible team over at Magnificent Works team. They just get it.
They really do.
And guys, if you use the code NOTARYNO50, that's NOTARYNO50, you get 50% off the first year annual plan. So go check that out, log those witnesses properly, and protect your business. All right, we are back. Moving into segment 2. We are calling this proxies, marks, and out-of-state oddities.
This is where things get really weird legally.
Yeah, because we're dealing with signers who are physically impaired, or maybe they're crossing state lines where the rules just totally flip.
Right.
Okay, MCQ 4. Let's talk about Connie up in Connecticut.
Okay, Connie.
So Connie is asked to notarize for a physically disabled signer who wants a third party in the room to sign for them. This is called a proxy signature.
Right. Very common request.
But the document they handed her completely lacks a notarial block.
Oh, that's messy.
Right. So, question, can Connie attach a loose certificate to perform this proxy notarization?
The options are?
Option A, yes, if she notes it in her journal. Option B, yes, but only with 2 witnesses. Or option C, no, Connecticut does not permit proxy signatures.
Take a second, everyone.
Proxy signature, no block, Connecticut.
All right, the reveal here is C, no.
Really? They just outright ban it?
Yes. This is a huge trap because while states like Colorado allow it, Connecticut strictly prohibits signatures by proxy.
Wow.
The principal actually has to make some kind of mark themselves. And on top of that, Connie was dealing with a document with no notarial block.
Right, so she was just going to slap a loose cert on it.
Which brings up the massive danger of floating loose certificates.
Floating certificates?
Yeah, if you just attach a loose form to a document without permanently binding it and detailing exactly what document it belongs to, a fraudster can just unstaple your valid certificate.
Oh my God.
And attach it to a totally fraudulent document.
Wow, they literally steal your seal.
Exactly. So Connie would be breaking state proxy laws and potentially facilitating fraud.
That is terrifying. Okay, well, let's look at the flip side of that. Let's go to MCQ 5.
Let's do it.
Whitney in Wisconsin.
Okay, completely different jurisdiction.
Very different. Whitney's dealing with the signer who is physically unable to sign a real estate document. Same basic setup.
Right.
So, does Wisconsin law, specifically WS1 40.09, require Whitney to gather 2 disinterested witnesses for this proxy signature?
Options.
Option A, yes. Option B, no, the signer simply directs another individual to sign. Or option C, only for out-of-state property.
Okay, I'll give you a couple of seconds to think about Wisconsin law.
Yeah, is it as strict as Connecticut? Let's see.
The reveal is B. No, she does not need extra witnesses.
So Wisconsin is just chill about it.
Yeah, it's fascinating. Wisconsin law allows the impaired individual to just direct someone else to sign right there in front of the notary without mandating additional witnesses.
Huh.
But, contrast that with states like North Carolina or South Carolina, where they have incredibly strict witness rules for proxies.
So you really can't just take what you know from one state and assume it works across the border.
Never. That will get you into so much trouble.
All right, speaking of South Carolina, that leads perfectly into MCQ 6.
Perfect.
We've got Emily in South Carolina. She is notarizing what's called a signature by mark. So basically the signer is just drawing an X on the line.
Right. They can't form letters, but they can make a mark.
Exactly. Now, can Emily just use her fancy metal embosser to make that X look official?
Okay.
Option A, yes, an embosser is sufficient. Option B, no, she must write specific statutory text below the mark. Or option C, no, she must use a rubber stamp facsimile.
Think about this one. It's about procedure.
Yeah. We all love our embossers. They look so cool, but do they hold up in court?
The reveal is B. No, she must physically write specific text.
You literally have to get a pen out.
Yes. Under South Carolina Code 26-1-90, Emily is required to physically write the phrase, mark affixed by, and then the person's name, in presence of undersigned notary.
Wow, so you can't just squeeze a metal embosser on it and call it a day.
No. An embosser might look incredibly fancy and official to the client, but it will not save you in a courtroom if that required handwritten wording is missing.
Yeah, the judge doesn't care how pretty the paper looks.
Not at all. It's about the statute.
Okay, last one for this segment, MCQ 7. We've got Mary in Maryland.
Okay.
She is chatting with a colleague down in Florida about strict ID rules. Identification is everything.
The bedrock of what we do.
So under Florida statute 117.05, which of the following is actually an acceptable form of identification?
Okay.
Option A, a library card. Option B, an expired passport from 10 years ago. Or option C, an identification card issued by any branch of the U.S. Armed Forces or a veteran health ID.
Okay, take a couple of seconds. Think about Florida's ID laws.
Well, obviously the library card is a joke, but the expired passport 10 years ago, I don't know.
All right, the reveal is C, the military or veteran ID.
Okay, so why not the expired passport? It's a federal document.
Florida is incredibly strict. A 10-year expired document is outside their acceptable window. The parameters for acceptable IDs are rigid, and for good reason. Relying on the proper, statutorily approved ID is your ultimate shield against E&O lawsuits.
Right, because if you accept an expired ID and it turns out to be a fraudster, your insurance is going to look at your journal and say, you didn't follow the law.
Exactly. You lose your coverage.
Wow. Well, that's heavy. Let's take one more quick break. And hey, if you want more of this kind of detailed breakdown, you have to check out our video podcast, No Notary, with Eddie Montes Travis.
It's a great show.
It really is. He dives deep into the visuals of this stuff. And also, for those quick tips when you're on the go, make sure you tune into Marylyn's 90 Seconds of Notary.
Just quick, high-impact tips to keep you safe out there.
Exactly. We'll be right back.
All right, welcome back. We are on to our final segment, segment 3. The bad, the fraudulent, and the ugly.
Yes, real-world E&O cases that landed people in court. Yeah, this is about the financial ruin that comes from cutting corners. Or in this first case, the ruin that comes even when you do everything right.
Which is the scariest part.
It is. So MCQ 8, we've got a notary who perfectly followed all ID and notarization procedures for an elderly signer's holographic will-so, a handwritten will.
Okay, textbook perfect execution.
Absolutely perfect. Question. What was the legal outcome for this notary? Option A, they completely avoided court because their journal was perfect. Option B, they were sued and lost $7,000 in legal fees from their E&O policy. Or option C, they were fined by the Secretary of State.
Think about this one. It feels like a trick question.
Yeah, I mean, if you do everything right, you shouldn't be punished, right?
Well, the reveal is B. They were sued and lost $7,000 from their policy.
Wait, why?
Because it's a will. When you notarize wills, you can easily get dragged into a brutal probate dispute.
Yeah.
The family members who didn't get the money are going to challenge the document, and you, as the authenticator, are basically ground zero for their lawsuit.
That is just wild. It's like being a perfectly safe driver sitting at a red light and you still get hit by a runaway truck.
Yes.
Liability just exists everywhere in estate planning. You have to have that insurance just to defend yourself even when you're innocent.
Exactly. The policy paid the defense attorney to get them out of the lawsuit.
Man. Okay, MCQ 9. Let's talk about California penalties.
The fines out there are steep.
Very. So, a California notary, knowingly, keyword, knowingly accepts a fake ID because they want to rush a real estate transfer for a buddy.
Big mistake.
Huge. What is the maximum civil penalty the California Secretary of State can impose for this willful failure to discharge duties on a real estate deed?
Okay.
Option A, $750. Option B, $1,500, but jumping up to $10,000 for a false acknowledgement on real estate. Or option C, $100,000.
Lock in your answers.
Willful misconduct on real estate in California.
The reveal is B.
So it's 10 grand.
Yes, up to $10,000 for real estate. See, negligence, an honest mistake, is a $750 fine. But willful misconduct jumps to $1,500, and if it's a false acknowledgement on a real estate deed, it skyrockets to 10 grand.
Okay, but I mean, won't their E&O policy just pay the fine?
No. E&O insurance covers errors and omissions mistakes. It explicitly will not cover willful acts or fraud.
So they are paying that 10 grand out of pocket.
Out of pocket plus whatever the victim sues them for, it's financial ruin.
Wow, do not mess around in California. Or anywhere, really.
Right.
All right, our final question, MCQ 10. This one is called the rushed car window.
Oh, this case always makes me cringe.
It's rough. So a notary is pressured to quickly notarize a warranty deed. The guy won't even get out of the car. It's through the window.
Red flag.
Massive red flag. And in her rush, she misses the fact that the name she puts in her journal does not match the grantor name on the warranty deed.
Oh, she missed the mismatch.
Yeah. So how much did this rushed mistake cost her $100,000 E&O policy?
Okay, options.
Option A, $700. Option B, $14,000. Or option C, $73,000, which was a $55,000 settlement plus $18K in legal fees.
Let that sink in for a second, folks.
Rushing a car window.
The reveal is C, $73,000.
Over one mistake.
Yes, because it was real estate fraud, and she facilitated it by not paying attention.
Look, my takeaway here is so simple. Never relax your standards in a rush.
Never.
If the client is in a hurry, that is their problem, not yours. You take your time or you walk away.
It's the only way to survive in this business. And, looking at all these cases, I have to leave our listeners with a bit of a provocative thought today.
Oh, lay it on us.
Well, we know California already mandates biometric right thumbprints in your journal for real estate transfers to prevent this exact kind of fraud.
Right, the physical thumbprint.
Right. So with states dealing with these massive multi-state counterpart signings and all these E&O lawsuits, how long until biometric journal mandates become the national standard for all high-stakes trust documents?
No.
I mean, a signature just isn't cutting it anymore for a $10 million trust transfer.
Yeah, that is definitely something to think about. The future is probably going to look very different very soon.
Absolutely.
Well, if you guys have thoughts on that, or if you just want to know more about this stuff, email your questions to derek@dereksproul.com. We will try to answer as soon as possible at the end of our shows.
Please do. We love hearing from you.
Yes. All right, well, let's do the credits. Exec producer, Derek Sproul. Lead writer, Marylyn Lee Trotter. Graphics, Eddie Montes Travis. Music, Thomas Bynum. And produced by Magnificent Works Business Solutions.
Great team.
The best. All right, everybody. Don't just be listeners of the knowledge, be doers of the knowledge. This is notary knowledge. Until next time.
Are you truly protected as a notary public? Navigate the complex legal framework with confidence using Notary Law and Liability by Derek Sproul. This essential guide provides a deep dive into state regulations, ensuring you stay compliant across jurisdictions. Learn how to properly use errors and omissions insurance and master the critical boundaries to strictly avoid the unauthorized practice of law. Protect yourself, your commission, and your business. Get your copy of Notary Law and Liability by Derek Sproul on Amazon.